Welcome back to StarTalks, Anup sir. Thanks for providing your valuable insights on the technological evolution, the IPR, and the cyber laws and the other concepts on unraveling cyber threats, exploring the world of online safety. Let's continue our discussion in today's episode on the AI systems, that is, the artificial intelligence systems, and the jurisdictional considerations regarding the usage of those systems in India. We will dive into the concepts of artificial intelligence and the related liabilities, as well as the current legal framework and other aspects while discussing with you. With that, let me start with knowing from you, Anup sir, what measures has India taken till now to regulate the artificial intelligence and the cyber laws till date?
Thank you, Siraj and the team of Advotalks for having me here again. And we love discussing the technological advancement and developments in India, as this is very relevant for all of us. So yes, now I'm addressing your first question about the regulation of artificial in India, artificial intelligence. The thing is, unfortunately, we have no specific regulation in India for artificial intelligence, not even any rules. But in this regard, Niti Aayog in the year of 2021 issued an approach document which was addressing the concern, and they in that document they like somehow are trying to reflect their intention, the government intention, that how they see the development in artificial intelligence. And other than this, we have no other like regulation at all. But when we talk about the portions, or like what kind, like how India is dealing currently, like I'm clarifying, by the way, there is no regulation in India, but still things are running, going on, keep developing. But how we catering these developments is like, um recently European Union issued a Artificial Intelligence Act. So I was just growing, just when I just look into the legislature developments around the globe, I try to manage and keep update myself regarding these developments, and also trying to uh, draft document which could be helpful for Indian legislation. So in that part, like I can like summarize today, and our audience need to know that what is artificial intelligence as per the definitions by the governments. European Union defining artificial intelligence as a body system coded software which is seeking information and providing solutions for any problem. But this definition by the European Union itself is not complete. The artificial intelligence and technological developments is keep growing day by day. How I can say that this definition is not covering, if you can see in a nowadays, the technology like recently more technology is introduced by companies like OpenAI. They launched the video making software, where on just a few commands they developing entire video, and that video is looking so much realistic. In this process, we're not getting any solution, but we getting a proper, I can say, a picture, and that is a reflection of any idea. So this definition is not covering this kind of a development. So that's why this artificial intelligence should be keep developing, and India should start working hard on this. So in the previous session, I was talking about the Cyber Commission for India. So yes, only these kind of a body can cater. First of all, we need a specific regulation on artificial intelligence, and then this kind of a body, Cyber Commission, and the commission working on the artificial intelligence technological developments in India, can cater these kind of a developments and can control the actions by these things.
So thanks for bringing this, the understanding of a need of the Cyber Commission and also the role of Niti Aayog that you mentioned. I would probably like to understand a bit of, illustration from the usage perspective as well as the end user perspective. So we always try to understand who is the service provider, and there may be a lot of individual entities in the form of intermediaries, involved in the whole ecosystem of the artificial intelligence, or for that matter, any IT system. So, do you think that there should be a demarcation of the liability of the service providers, especially when it comes to the ones which are providing the AI related systems, and how it is going to be kind of useful for the AI related matters, Anupji?
Actually, first of all, we need to understand what is intermediary and why intermediary playing a major role in these kind of developments. Intermediary is a platform, software, or anything which is providing you or allowing you, giving you the platform where two and more people coming together and interacting with each other and sharing information or anything digitally. So, in this current era, the role and restriction should be very specific on these intermediaries, because major infringements is happening through only and exclusively through these intermediaries. Google is there. I will first of all pick up the Google and then social media platforms. Yes, Google is kind of an intermediary. By the definition is that if something is available in the universe, Google in just in some prompts providing you the information, and you, the user, by just clicking on that result provided by the Google, you reaching to that platform. So Google provided you the information, you reaching to that platform, and you start doing actions, what, like whether it is legal or illegal. So Google must be first of all responsible for these kind of a thing, for infringement. Assume that there is a website which is providing the service of uh, data, like the leak data, the data which should not be made public, and Google in its result providing you the website name and providing you the links, then Google must be first of all punished for that. That yes, Google is providing you the illegal sources. As if you just, not only the data protection is there, there is a lot of illegal websites running around the globe. First of all, these major intermediaries and these tech giants should be very like a responsible. The more bigger you are, the more responsibility you holding. Then that's you should first of all keep this thing in mind, that you have the power to regulate the entire society. So government should first of all keep their eyes on these intermediaries. Then I come to the social media platform, like on the X, previously Twitter, Instagram, and all. Like major IPR infringements is happening through these platforms. So like anyone can use anyone's pictures, songs, and the pornography is like rapidly growing, and this is a dangerous, uh, very dangerous for the society. If the pornography is keep increasing, then the responsibility of these intermediaries should be very specific, and they should be liable for this. And again, like in this discussion, I would like to mention that the, like the regulation for the intermediaries is available through Intermediaries Act 20, not act, that is a rule framed by government in 2021. So that is bringing kind of a rules for these intermediaries. They are making liable for the pornography. They talking about the establishment of a body which is addressing the major concerns, violations, and all. But there is a major lap. Is like I found some major laps in these intermediaries. How is that? Like they are not talking about the IPR infringements, they are not talking about the artificial intelligence results. If something is some false information is being provided, by someone and they're just putting into the social media, then what repercussions can be? They can impact a lot. If you see, in just one day before of election, that our Mr. Arvind Kejriwal, the current Chief Minister of India, Chief Minister of Delhi, taking bribes through a video, and that video was not original. That video was made through artificial intelligence. By the way, the entire generation is not that much educated, so that they can, in the first instance, they clearly categorizing, or they can clearly understand that this is a fake or not. But like that kind of a video already making damages at the time of publication. So my point is very specific. These intermediaries cannot be left alone, cannot be left spared. They should be punished. They should be liable in these kind of a circumstances. And for the government is still that if the regular update is coming, the regular major threats and major artificial intelligence kind of a artificial intelligence development is happening, so we should cater these developments instantly without losing time.
Thanks, sir. Thanks a lot for bringing that importance of, catching up with the time and with the advent of the technology, especially the artificial intelligence, which is the core of our discussion today. The legal framework should also develop. I think like that's the key takeaway for us discussing on this. So we have a lot of other aspects that we wanted to talk to you on, the data protection, and as well as maybe talking about the fiduciaries demarcating the parties and then whom to be accused, and especially in the aspect of the cross-border transactions. We will come back to that, but can you, give us the understanding on the most discussed topic as of now in the AI, which is about the content creation, and there is still a lack of clarity, like the recreation of an artistic work by the AI system. Like you have mentioned about the capabilities of the AI systems in the previous episode as well. So we wanted to understand like the recreation of the artistic work by the artificial intelligence systems, is it considered legal or it is considered an illegal, and there are legal repercussions in India, and how these can be addressed because of the right now we can see there is a rapid activity that is happening in the, especially in the social media and today's digital world. So the recreation of the work by AI is going to be a norm in the coming days. So how we are going to control through the legal framework, Anup sir?
These development is still keep growing, but I can segregate these things in in two ways. First of all, the regular, and that is and the second is irregular. In the first regular, these intermediary majorly talking about the Instagram and other, not the intermediary, not the social media, but the platforms kind of which is providing this service, exclusive service of artistic work, edited artistic work. So these intermediaries paying to the real owner. Yes, that is happening. But when we talk about the artistic work generated by the artificial intelligence, the thing is, the real owner is getting the remuneration, the royalty for the infringement happening or for the use of artist of their artistic work. But what about the artistic work generated by the artificial intelligence? I previously mentioned there is no artificial intelligence specific, no regulation is available in India. That's why we are unable to compensate the real owner of that artistic work. So that there, how there is a lapse and there is a uh, there is a possibility to address these kind of issues. And when I talk about the content created by artificial intelligence, so yes, we need regulation, but at the same time, we need the responsibility and the extent, like what at what extent we can add it, or what at what extent we can generate that artistic work. That should be limited, and that should be limited, like assume that there is a voice of Amitabh Bachchan, and Amitabh Bachchan is till now not provided any authority to any artificial intelligence body or artificial intelligence platform, and they have not given their voice right to any platform. But that platform is uttering the obscene words, and you may be hearing the obscene words from the Amitabh Bachchan. So at current time, there is no liability can be arisen. Amitabh Bachchan cannot seek any kind of a remedy in this for the misuse of these kind of artificial intelligence infringements or the artistic work. So we need to understand that how grave it is and how intense damage this can create to our society. This is not only exclusively about the artistic work, this is also about the data privacy. If something is available on the internet, if I publishing a research work and that research work is being provided in the result of chatbots, if you just typing anything and you getting the result and that result is containing my research, what about that content? So the liability is not certain in a current time. So we need to understand that yes, these are the domains where we need to work more and harder, and where we can go if someone is publishing my content without my authority. But at the same time, US has a very interesting law, that is DMCA, Digital Millennium Corporate, not a corporate, Copyright Act, 1998. So we need similar kind of a act in India. This act is providing for the digital infringements. This is very impressive, and the audience should first of all they should read it, that how effective this is. And this is also like a not only US, this is working all around the globe, but India needs these kind of regulations in India too, because if some infringement is happening in India, you can directly report it digitally. That DMCA is providing the kind of a service. If you are a digital owner of that artistic work, you can just report and you can seek a remedy, or you can seek a removal of that particular information from any web content. So yes, we need these kind of regulation in India.
Thanks for helping us with the demarcation, especially as you mentioned the usage wise as well as the generation wise, the regular usage or the irregular usage. Like you have brought the example of the celebrity Amitabh Bachchan's voice being used for probably in an unlawful manner without a consent of that particular person, and probably that particular aspect should be looked into whether something can be considered a lawful or an unlawful act in this aspect. And also thanks for referring to the digital infringements related policies that are available across the globe, and especially in the US, as you mentioned. Right in the year 1988 itself, you have mentioned that it has come. So definitely there is a need for India to make a fast movement towards getting the framework adjusted. So let's try to grab some more understanding from you, Anup sir, on what are the various jurisdictional considerations regarding the usage perspective, like on the AI systems in India, like from the user perspective or the usage perspective, rather than on the aspect of someone who is creating or probably providing the service.
Absolutely. If I talk about the jurisdictional thing, I should be more specific, that if a user from Japan is uploading a picture without my consent, uh, not if uploading any artistic work without the consent of a real owner, then who will be liable and how that person can be held liable? Who will be liable? Why I said that? That intermediary platform should be held liable, or that specific person should be held liable? I see that for the jurisdictional purposes, that platform should be held liable first of all. That should be their responsibility, that no infringement is happening. no infringed content is being uploaded on their platform. There should be some automated there is some automated I can say the technology which is removing instantly. Yes, Facebook is working on that, and X is already working on that, but that those things are not effective one. So jurisdiction wise, first of all, that platform must be held liable, and then the person who is intentionally uploading or playing the major role in that infringement of IPR should be held liable. If we talk about India, that the liability clause or any regulation is missing, but we see that the relevant provision is available in the Intermediaries Rules 2021. In that rules, government is talking about the removal of a content on a request and setting up the automated regulations for that intermediary, but not talking about the jurisdiction, but not talking about the liability, not talking about the compensation. So these are the loopholes available in the current intermediaries rules. If someone from Russia uploading or infringing the right of any artist in India, how and when and at what extent that person or that intermediary should be held liable is missing. So these things should be added. And how, like, one, my personal opinion is that how the jurisdictional issue can be addressed to setting up a body or a authority in India, not apart from the cyber commission. If the body is available, like that intermediary is working in India, they should have a physical office. So yes, the current intermediary is already talking about having the physical address in India. They are talking about the setting up of the office, but at the same time, they should add these kind of a provision, the liability and the compensation for that artist. So yes, and also the major, I already recall that if someone from the outside the territory of the India, if committing any infringement, then the liability should be certain, and the how that person or that individual would be penalized, that should be more certain.
Okay, sir. Thank you, sir. Thanks for bringing the understanding on the intermediary rules 2021, which speaks about the removal of the content if at all there is a request from the external party, and also bringing up the understanding on lack of clarity still even today on the liabilities aspect, as you mentioned. So this definitely unveils kind of a bigger discussion in the form of a need of cyber commission that you have been watching and advocating from long, from your individual as well as professional perspectives. So we would limit our discussion for this episode on the aspect of time. So that's about the episode of StarTalks with Dr. Anup Tiwari, which brings a lot of insights on unraveling the cyber threats, exploring the world of online safety, and introduction of the AI systems and the jurisdictional considerations regarding the usage in India. Like we said, we would also be covering more queries on the need of a cyber commission and a concrete cyber law framework in India with Dr. Anup Tiwari, sir. Stay connected for the final episode.